Welcome to episode 235 of Sports Geek. On this week's episode, I chat with Cassandra Heilbronn on sports law and sponsorship agreements.
Welcome to Sports Geek, the podcast built for sports digital and sports business professionals. And now, here's your host who has a new keynote ready for your conference, Sean Callanan.
Yes, I am Sean Callanan, and yes, now I do have a esports keynote ready for your conference or for your board to understand esports, and I share what I've learned so far on the journey with SG Esports and with Gravitas and League of Legends and the OPL. If you're interested, please reach out and get in touch with me. You can do so via email, sean@sportsgeekhq.com, or via social media @Sean Callanan or @SportsGeek. You might be listening to this podcast on your favourite podcast channel. Let me know what it is. Send me an email, message me on LinkedIn. Tell me when and where you started listening. I really appreciate people reaching out. Dan Curran recently reached out to me via LinkedIn to say he's started listening, as did Ollie Scheuer as well. Thank you very much. I really do appreciate the feedback. Whether in whatever form it comes, Twitter DM, LinkedIn, or email. And yes, if you want someone to talk about esports and help your team understand esports, I'm happy to have that discussion. But on Keynote, it actually allows me to announce a speaking gig. I'll be speaking at Youth Marketing Australia on May 23 here in Melbourne. Youth Marketing Australia is a curated single-stream conference designed to help marketers and brands keep up with the fast-paced nature of Gen Z or Z. So really talking to the market that esports really talks to quite well. So I'll be doing an esports keynote, helping brands understand how they can connect with esports and gaming audiences. There'll be speakers from Spotify, Vice, Pedestrian, Junkie Media, Broadsheet, MTV, Frank Body. So I'm looking forward to listening and learning from other speakers and talking to brands about how they're trying to connect with that younger market, with Gen Z, which is really is valid in esports, but also in sports overall. How are you talking to this market that is consuming media differently and looks for a different relationship with their teams and what they're following and their interests? So if you're interested and you're in Melbourne and you're interested in that market, simply go to sportsgeekhq/YMA. It'll send you to the link, and if you use the code 100 off, you know what you get? You get $100 off. That's a pretty good effort. So if you're coming along, let me know. Looking forward to it on May 23 here in Melbourne. This is my guest this week is Cassandra, I should say, Heilbronn. She's a lawyer from Minter Ellison. And we discuss all things sports law and sponsorship. So I hope you enjoy this conversation. Very happy to welcome a good friend of mine. We've done the sponsorship and sports marketing conference circuit and cross paths regularly. Cassandra Heilbronn from Minter Ellison, welcome to the podcast.
Thank you very much for having me.
And yes, we did cross paths. We are Money in Sport alumni, and you recently hosted their recent mini-series here in Melbourne on sponsorship and partnerships.
That's it. I reckon you and I could say we're the OGs of Money in Sport.
Yes.
We've clearly got that title.
Yeah, exactly. And shout out to Luke and Lou and obviously all the boys there that drive Money in Sport. But wanted to talk to you because you gave a presentation as well as emceeing. You then spoke about your role as in sports law and talked about some of the good, bad and the ugly of sponsorship agreements. And I thought it was interesting because I think it's something that a lot of sports marketers don't pay attention to. It's a really important piece. But before we get into that, how did you get why sports law? How did you get into sports?
Well, I've been practicing for 12 years as of last week.
Okay.
I have always wanted to be a lawyer, but I also wanted to be an elite athlete. Unfortunately for me, my chosen sport was hockey.
Okay.
So there was a number of limitations for me for pursuing that to a higher level. And my dad always used to say, look, you can't have a career in sport, one injury, and you are done. So thankfully for me, I had a bit of the smarts on the side and I was able to pursue my goal of being a lawyer. The very first firm I worked at was involved with sports. Up on the Sunshine Coast. They were actually one of the feeder teams for Manly Sea Eagles in the NRL. And sports law is not like, say, property law where there's a set legislation or a set textbook. It's a combination of a number of areas of law. And thankfully, my formative years as a junior lawyer set me up perfectly for that. So criminal law, torts and negligence, and then contracts. I've just been able to capitalise, I guess, on my love of sports and also involvement in sports from a young level. I've been a coach, a player, administrator, and also acting for a number of clubs and players and anyone you could possibly imagine it. So I've been lucky to be able to, I guess, make a career out of it.
And is it because there is, like you said before, it's not as cut and dried as criminal or property, that there is a lot of variety and in the space?
Oh, that's it. And you cannot solely specialise on sports law like you would the other areas of law, because you just have to have that combination of skills. It's worked out perfect for me, and of course there's a number of perks that go alongside with it.
Get to go to games, get your walls of doom with signed jerseys and the like.
Oh yes, I've got a Harvey Specter lookalike office down here in Melbourne, and the invitations to events, it's amazing. It can be tiring at times, but I was only saying on the weekend, I've never been to an AFL match in general admission. Which is, I really want to experience it. I was offered some tickets the weekend to the Cats game, and I was like, yes, general admission. They're like, no, the medallion membership. So I was like, no, can't go. I need
Sports
GA.
lawyer problems.
I know, right? Life of a lawyer.
So getting into the discussion or the presentation you gave at Money in Sport around like the role you play and lawyers play in sponsorship agreements, right? So everyone's out there trying to secure sponsors, whether it's for front of jersey, to do digital activations, because it's a big revenue generator for sports. You know, in traditional sports, it's a third of the revenue. It's sponsorship, TV, and ticketing. So sponsorship is a big part of that. And then agreements are a big part of actually making sure that money gets paid. And I think that's how you sort of open. It's like the importance of the agreements and how. What are some of the key things that you look for and the important things that sports marketers need to understand from a legal side of things?
I guess making sure that the intentions are reflected correctly, first of all. And I used the example of an apparel company that might also do merchandising. If it's just an apparel contract, you need to say that from the start. The team later on could be under the, the belief that they will be getting water bottles and football boots and bags when really they're only getting a jersey. So that's probably number one. And
then likewise, the other way is you go get your apparel deal, like you said, you get your agreement, and then you want to do a casual line or a T-shirt line with a cartoon on it and that kind of thing. You say, oh, cool, we can do that. And an agreement could preclude that.
Yeah, that's it. And it's interesting you say that because it comes down to the words. There could be an apparel deal, but there could also be a premium apparel deal. And that could be the difference between your first grade team and the junior team. So you need to be really particular about that type of thing.
And so that's where, I mean, words matter, and that's where your field of play, I guess. Where do you find sports as a general rule are falling over in that space?
Oh, look, with the utmost respect to everyone negotiating the agreements, it's good that the general managers, the commercial managers, the CEOs really want to be involved in this. They want to sign the deal, get it done as quickly as possible, but they're just not speaking to their lawyers about the right things or at the right time. We try and prevent that by giving our clients a suite of precedent documents. I make it so they have to limit the number of changes in the substantive part of the document. I don't want them messing up the indemnity clause. Quite often they have no idea what that means.
So explain that piece, and I guess the dangers of, because I'm assuming a lot of clubs will go, oh, here's our sponsorship template, or here's one that we've used previously. I will just change a few pieces. explain what some of the important parts that really shouldn't go about changing.
Sure. So the indemnity clause basically gives you, it doesn't stop a claim being made against each other, but it limits the liability.
Okay.
If I use the apparel company, for example, they don't want to be giving, or a club rather, don't want to be giving the apparel company a contractual indemnity for the negligence of the apparel company. So if they produce goods that are of bad quality, we don't want the club to be responsible for that. That's the responsibility or the liability of the apparel company. And quite often with a contractual indemnity, the insurers will just say, if you've given one for the other side's negligence, your policy doesn't respond, you don't get to claim any damages, and you're up for them personally. The language is quite complicated, and I mean, we spend hours with junior lawyers teaching them about indemnity clauses. They are complicated. They're not easy to draft and necessarily understand. So when we do it in a particular way. That and then probably the termination clause to round off the top three. So the recitals, the indemnity, and then termination. Yeah,
so on termination, which is always, it's like the ugly bit of sponsorship when it goes wrong and, you know, the divorce, so to speak. Mm-hmm. What are some of the tips or what are some of the things that sporting teams or rights holders, because it's both sides, what should they be looking for in that termination? You know, how to end it if it's not all hunky-dory and we all go through to the end and everyone's fine and everyone's happy and there's a lot of backslapping in the end. Not all agreements end up that way. What are some of the things you need to look for in the termination side of things?
You'd want it to be mutually exclusive, so a mutual rights or mutual benefit for termination. A lot of drafters for their client will just give their client the option to terminate and not the other side. You think that might give them a little bit more, quote, power. It doesn't. It actually makes the agreement a lot more complicated, and the party who has drafted the agreement may lose that benefit because they were the drafters. So we want to make sure that both sides can terminate on equal grounds. Of course, if someone, say, is giving a license or a distribution agreement, they need to put in a lot more steps for termination, handing over the product, protecting the intellectual property, and making sure that any clubs or teams that a licensee has signed with, that can be assigned back to the actual license holder.
And then so from a sponsorship point of view, what happens when, and we've seen this, you know, we've seen clubs, you know, being in a real dire straits when a sponsor folds, leaves the market, decides they don't want to do it anymore, whatever reason, and is that where, you know, that's where you do your best work? Is that where the lawyer work either done up front or in negotiating that exit of that type of contract? Sure,
and a lot of the times we might ghost this work, which is fun, but for me, I enjoy it a lot more if I'm actually negotiating.
So when you say ghost, you're providing advice to the commercial managers and those kind of things to sort of get them through that minefield?
Yes, so I'd be drafting a script. I would draft likely questions, how they could respond if they receive that question. Because the termination clause gives you the ability to terminate, but that doesn't mean you can't negotiate a resolution outside of that. You can look to have a deed of release alongside it. We just have to look at the coaches who leave the teams early.
Yeah, I mean, the dance that happened between the Rabbitohs and the Broncos where they swapped coaches.
Essentially,
and there was a bit of a standoff when Anthony Seabold went to the Broncos, and then it was like, well, is Wayne going to leave early? And that toing and froing. I'm sure there's lots of negotiations happening in that behind the scenes.
Yes, and the resolution might not be exactly in line with what the agreement provided for. That's great because we've negotiated, we've come to mutual terms, and it will likely contain releases, so they can't sue, make a claim based on anything that's covered in that resolution. And that's why we don't often see, if you use the coach example, reasons for coaches leaving or an extended explanation, because it's all contained in a hopefully tightly worded deed of release with agreed statements and agreed media releases.
So even just in the conversation in the last 10 minutes, we've hit on like HR and sponsorships, licensing, and that's just where, as a sports lawyer, you've got to have this multi-skill to be able to lean on other people that have the skills in that area, but then apply it to sport because it is a bit unique in that nature.
And that's it. You can't negotiate these type of agreements as you would in a normal employment environment or a normal corporate environment. My clients are worldwide, so from say 3 a.m. to 9 a.m., I have to almost be on call dealing with any issues coming out of the Americas, then dealing with Australian time zone during our day, and then from 4 p.m. to 10 p.m. dealing with the Middle East, Europe, UK, and things like that. You have to have that knowledge of the sporting industry, because when I have a client call up and say, look, we want to trade this player to X team, this is the agreement, can you look over it? I need to know what the rules and regulations are overseas. And if you were to go to, say, a general commercial lawyer about that, they wouldn't know what the Asian regulations are. They wouldn't know what the Japanese league requires, the Korean league, the MLS. There's a lot of nuances, and I guess that's what makes it fun.
Yeah. And then the other stuff is how the tax and the tax system starts impacting all of those all those legal agreements. Like, one of them is the usage of player image rights, and it's been a long-standing opportunity for players and athletes to drive revenue, not just the top-tier athletes in AFL and NRL and the like, but it's a real vital one for the sports that don't get a lot of funding, where they're Olympians and those kind of things, is using their image rights as a means to produce revenue and as a tax saving. How has the law changed in the way the ATO views that? It changed things from an athlete manager, but also teams that have been effectively on-selling those rights to sponsors. How's that all changed?
I think the most succinct way to say it is post-August last year, 2018, if there wasn't an agreement already in place, players can no longer assign their images to a company or family trust, who could then use the license to exploit, which is in the legal sense, that image. And the reason why they used to assign it to that company or family trust was the tax benefit. Tax on a company is 30%. Family tax or family trusts, the dividends, depending on what's paid with those, the tax could be minimal. Whereas putting aside any agreements that were in place prior to August last year, if there wasn't one, the players have to solely contract with the third party themselves as an individual person, meaning they'd be subject to the 47.5 thereabouts tax. It's a lot of money.
And it's a bit unfair. Like I do feel for the athletes, especially the ones where it was a real solid vehicle for them to generate revenue, because they were sort of caught up in this, because it sort of came in around the Insta influencer. That's where it's saying, hang on, there's these people making money off their rights and not paying tax. And so that sort of was where it was coming in. But it's sort of like the sports stars sort of got caught up in that sort of movement to get tax from those people, and those sort of collateral damage almost.
That's it. And I do feel for the athletes with that, because these are legitimate agreements for legitimate image rights. It's separate to appearance fees. It's separate to their playing contract, which is for their services on the field. But with the rise of the Insta influencer, from a non-athlete perspective, people receiving paid posts, goods for posts, I guess the government's just looking to make sure everyone's protected but assessed on the same level. My personal view is that I think there needs to be exceptions for professional sports persons. There's been a plethora of litigated cases about it. Andrew Eddinghausen, ET, he was the first one to pursue image rights issues in the legal sense, and I think it's a great way for them to market it and benefit from it, because they are a commercial entity. Yes, they're employees of a team, but you just have to look back to Anna Kournikova. Sure, she was a good tennis player. She wasn't one of the great ones, but her sponsorship deals, that's how she's been able to make a living. She wouldn't have been able to do that to the extent that she used to right now in Australia.
I mean, and that's the thing. So that whole player IP and their own rights, that was a whole development 15 years ago with, Ricky Nixon setting up Club 10 and those kind of things, and effectively forcing the AFL to change contracts and those kind of things to say, we have these rights. And now the ATO has sort of come in and asked for their piece of the pie. So it's ever evolving. Like, there's every chance that, and this is where lawyers and accountants and advisors will come in and say, well, this might now be the best structure for you to be able to monetize what you're doing and separate it and make a different business case to the ATO effectively.
That's it. And there's been a number of private rulings and non-binding rulings by the ATO about image rights and how they're treated for tax purposes. They did propose what was called safe harbour last year, and that essentially hasn't been put into practice because of the changes they made. But it was to propose a limit of 10% of a player's contract to be assigned to image rights. They were looking to do that because of the salary cap issues, particularly for players in the end of their contract. You might say that they're there more for their image on a side of a bus rather than their playing ability. The ATO's just wiped that out, or the government's wiped that out completely in terms of the limitation, but also the using the company as a vehicle. But there's
still it's still the ATO is figuring out this new system, like the ATO and the law is trying to catch up with, in this case, like the technology.
That's it.
And, because we're seeing pure digital influencers, streamers, YouTubers, that kind of thing. They're valid media platforms.
That's it.
And they're a valid way to reach an audience. And that it just doesn't fit in the square box that they've currently got.
That's it. And it'll be interesting to see what the governing bodies do, because from my experience, they've been really good, really proactive with the image rights agreements. Separate to a sign-on bonus, Australia has a very unique sign-on bonus system, but the FFA, AFL, NRL, most of the time they reviewed these image rights agreements and gave it the tick of approval before they were finally put in place. So they appreciate that the world's evolving, but also why not capitalise on our sports stars?
Yeah, and that's the thing, just putting, the ATO putting this in just slows innovation in that space. When we're seeing a lot of fans moving to athlete-driven media, we're seeing a lot of this player-driven media sort of channels that are popping up, both here in Australia but around the world, and starting to treat them like, they're like their own media channel. How do we tax media companies? Like, where does that fit? So the player image rights is one that I think is fascinating. When I saw it, it came out, I'm not a lawyer, I'm like, and I spoke to lawyer friends of mine, I'm like, this is going to be really bad for most athletes. The other one that lawyers do get involved in is these morals clauses and the discussion around that. We've currently got a really high-profile case at the moment with Israel Folau and him putting out being challenged and putting out a homophobic post, and Rugby Australia challenging him and going through hearings. From a lawyer point of view, how do you have to frame those morals clauses and those kinds of things, because they would have been more prevalent and more, they keep raising in profile as social media and digital has grown?
That's it. We usually refer to them as reputational clauses.
Okay.
And depending on who I'm drafting for, it will depend on how the clause is actually drafted. So if I'm acting for a club with a sponsor or a funder, I don't want the sponsor to be able to terminate simply because there is an event that could cause adverse or negative publicity. I want there to be a few tests subjective tests that they have to go through before they can actually terminate. I have tried in the past limiting it to the board and executive only in the course of their duties.
Yep.
So not even if they were on a drink driving charge or anything like that. Of course, players will inevitably be included in those clauses, but I don't want a sponsor, again, acting for a club, to be able to terminate immediately simply because something has come out in the media. There needs to be an onus on the club to take reasonable steps. They should inform the sponsor. They also need to tell the sponsor what they're doing to fix it. Are they starting an investigation? Are they having a meeting? What steps have they put in place?
What remediation are they doing? Are they doing education pieces, that kind of thing?
That's it. And if I'm acting for a sponsor, I want to make sure that they can claim for any losses if there is an event that has caused that adverse publicity. Years ago, they would simply terminate. We saw with Stephanie Rice many, many years ago, she lost her Jaguar sponsorship because of a tweet she put out. They just simply terminated because of that. These days, there would more likely be a reputational clause, damages clause in there. So the sponsor might have to take a few extra steps before it's done, but she was mature enough to accept she did the wrong thing, and from media reports, accepted the termination, and learned her lesson.
But from a brand point of view, like having the clauses in place, like they just potentially just say, we don't want any part of this PR nightmare. Mm-hmm. And that's why they're trying to get out and extract themselves out. And, they might try to use the morals clause, the reputation clause as a device to get out. But they, there is that harsh reality of, well, you've done this. They're either going to go really quiet till the contract ends, or they're going to exit some way. Mm-hmm. So it really becomes, from a club point of view, educating your players and your staff and those kind of things, that it is going to cost big money because it can be damaging really quickly.
That's it. It's always education. Everything in sports comes down to education, no matter the topic, whether it's this tweeting clauses, sexual harassment, ASADA, player welfare, mental health. It always comes down to education. And that's when players' associations come in. They play a key role in the relationship. They do a lot of the work that lawyers would ordinarily do. Most often they're legally qualified themselves. And I think a lot of people really underestimate their position. I
think the associations do a good job with very few resources. Like, it's really hard to reach 600 or 700 players every year, and, they'll do rookie camps and onboard them. But what I find, and as someone who's done athlete training and done it with groups, I find it strange that it's not done every single year. Because, one, the platforms keep changing. Like, every year there's a new platform and there's a new way of it being used, and they're using it in a different manner. And they don't have to all these public-facing platforms. A lot of the problems are arising on these private ones, WhatsApp and Snapchat, and messages being sent privately, and people think, I'm not sending it out publicly. I'm not sending out a picture that I shouldn't on Twitter and letting everyone see it. Most of the damage is happening in these private channels and the way that they're engaging. And with things like agreements and salary cap and what the teams can do with the players, there's a little bit of, we can't do too much training with the players because then that comes under additional services and we're helping them. And so it gets left to the association. And I feel for the players because there's no one, I guess, really giving them a lot of assistance in that space.
That's it. And I think there's 2 points with that. The first one is the clubs and, I guess, governing bodies being more creative with the way they're delivering the training. No one wants to sit in a room listening to training for hours on end. It can be boring, and, even I have the most limited attention span. Over the past decade, I think a couple of the NRL teams have actually done a really good job with their training in terms of sexual harassment, interactions with females. I was brought in for some clubs quite a few years ago to deliver that training. Some people were like, why have we got a really young, mid-20s solicitor delivering this training?
Yeah.
But I could relate to the players. I understood what all the terminology meant. I knew from the industry and my friends who played what was actually happening, and I could deliver it in a lot more forthright manner than, say, a middle-aged man who was given a briefing pack and told to read it out to tick a box. But the other issue that you touched on is that of time. And if we look at the AFL women, I'm not sure what next season's contract is, but previously it was 9 hours a week.
Yep.
The clubs have got them for 9 hours a week. Well, that's what they're paid for, to train, to go through physio, rehab,
team meetings, and
to actually play. If you only have 9 hours a week and all of these women are working to supplement their income,
it's hard to assess time for player welfare and education purposes.
That's it. Yeah. That's it. We could always do it when they're out kicking the ball and training, but I don't know how much.
But then again, the pushback comes to, the players doing extras are effectively doing time, attending these type of sessions outside those 9 hours, so effectively not getting paid for it, and that's not a great situation either.
That's it, and it's another example of how sports is different to the ordinary world. As a lawyer, I'm contracted for so many hours per week, but in most employment contracts, it's reasonable extra hours.
Yep.
That's included in that. If we move to the sports world, yes, they are employees, but they do have those nuances. It could be, the players need to be treated right because the players' associations will be there in the background taking the proper steps needed if something crosses that line.
One of the other things and one of the trends I'm seeing in the sponsorship space is we're starting to see more and more sponsors come on board and come to sport for the attractiveness of the audience and to acquire customers. And so it's a stronger objective than put our logo on the jersey and we want to see it in broadcast and it's an awareness piece. As more sponsors come with that acquisition focus, how are the agreements changing to be able to say, we get you X many sign-ups and we're going to get paid this, and so it becomes part. You're still going to get that awareness content piece and all of those things, but you're also getting this performance bonus on acquisition. How are the agreements changing to sort of cater for those type of agreements?
Yeah, so what we're doing with the agreements is extracting everything out to the schedule. So the clients are not changing the substantive part.
Yep.
But any extra terms they want to include, they can put it in the schedule. And one of those could be KPIs or return on investments. Ideally, what you would want to do is agree upon an organisation who could measure or provide those metrics.
Yep.
You could use the Instagram tools or Twitter tools to assess it on a high-level basis. But if a front of shirt sponsor is investing $4 or $5 million over the course of a season or two, and they want to know what value they're getting out of it to sign an even bigger deal, and this will work both ways for the club, you need to have those solid metrics. And the interesting piece around that is it's not just the number of people who have viewed it, it's the length of time.
Yep.
So organisations, or say if we use the BBL, for example, they are able to produce a report which shows how many hours of screen time each logo had. But we might want to know more than that as a sponsor. And there's this new piece about the customer engagement or their prompted
emotion. Response and unprompted response and those kind of figures.
So they're actually measuring emotion, which as a lawyer that sounds
it's getting pretty tough.
Odd, yes, but it's just amazing what they can actually do with that. But it's benefiting everyone, and I think it's also almost keeping a couple of people in check in terms of making sure they are meeting those metrics.
Yeah, so that's more on the, I understand the schedule of, hey, here's the deliverables of things we're going to deliver, and here's some of the metrics that we're going to say are considered success. Where I was leading to was, let's just say it's an energy retailer and you go, cool, it's a $500,000 deal a year, and then for every customer that you help us acquire over X, we'll also give you this extra piece. Is that it's becoming more and more commonplace there? Because they're almost like affiliate agreements and those kind of things. That's becoming more...
Yep, and they include things like minimum guarantees, minimum return on customers. The metrics you can put in is completely endless.
Yep.
Absolutely anything they want, as long as we can put it into proper words and you can measure it.
Yep.
Because there's no point putting in, all right, we want you to achieve 1 million views on Instagram every quarter. If that's never going to happen, or if it's always going to far exceed that, it's completely redundant clause. So we are finding a lot of those, and it's making sure everyone at the club and the sponsor are involved, not just the two people negotiating or signing off, because it's a completely different area from
completely. And that's what I find sometimes funny talking to the digital and execution teams of some of these agreements, that knowledge of those key KPIs, whether it be the value of the deal. So they've paid a lot of money, so it's really important to, these are the objectives they want. And if that doesn't flow down to your team, then you get this misalignment and it becomes really awkward around renewal time when you're like, well, we didn't get those views, or we didn't get that data you promised us, or we didn't get enough people to our event. And well, if you're not getting that communication of here's what the schedule is and here's what we're expecting.
That's it. And if you've got that in the agreement, use it.
Yep.
If you're not happy, if you're not getting the likes or the reach, the return on investment, renegotiate it or look to give a show cause notice, because it's a multi-billion-dollar industry, sports. I mean, it's 6% of the world trade. You need to make sure people are meeting their obligations.
Yeah, and so as you know, one of the words I hate hearing in the digital space is make good, right? And so how, and you've probably been a part of that, of, either a disgruntled sponsor that's getting to the end of the, I joke, the August to September time in the football world, the AFL world, it's like the terrible campaigns are coming. It's like you can do a Game of Thrones trailer for it because they're all doing these extra campaigns to make up for things that they missed the mark on. Is there anything like from a legal point of view or that can help mitigate those types of risks?
Sure, you make it quarterly.
Yeah.
Monthly, I think, would be too often, or maybe BBLs would be a bit. That would be the outlier.
Yeah.
But you need to have the quarterly measures, but also a good agreement will have, because it's a partnership. You don't want to sign an agreement and never hear again from each other until it's time to renew or send an invoice. So you should be having those quarterly meetings, and that needs to be discussed.
And so tying both your regular KPIs to those regular billing. So, every quarter you're sending out the invoice. It's tied to what you're doing. And so if you're seeing something in quarter one or quarter two that's a little bit amiss, you could be working on it.
That's it.
Starting that conversation on what works, what doesn't work. Should we do more of this? So that requires agility and flexibility, which sometimes agreements and lawyers don't have a lot of, right? In what it is. So how do you work in that space? Because I know I've worked on the club side, and there'll be an agreement that says the sponsor gets X many posts, and I come in and go, that's not going to deliver what your goal is. Let's do this instead. And so we effectively change it. But how do you work in that space when you've got something that's a bit, it says here's explicitly what you're going to get, and we've all decided to change it?
Easiest way to do that is with the schedule, just say, unless otherwise agreed in writing, golden words, because you can always amend that, do an addendum schedule to take into account any changes that have been made, new teams coming into competitions.
Does that, because that gives flexibility because, I think early on in Sports Geek, 7 or 8, 9 years ago, there was a lot of that, we will get this many posts. And I remember talking to someone in the NBA world who saw an agreement that said the sponsor will get a mention every time out, and just shook her head. They're like, "That's crazy! Every time we have to mention the sponsor." And so it's then it's a negotiation of no, this will be better. And so it's just a matter of having, because they sort of went from that to clauses like you will get campaign and content to the value of. So it gave a bit more flex and creativity to the digital team to be able to say, we can deliver something like that. So is it just a matter of having some flex and getting the right words? I forget what you were saying before.
That's it. And everyone needs to approach it from a collaborative point of view. But sometimes you just simply don't know how it's going to work, and you need to all work together to change that, to make sure you're achieving the overall purpose. Yep. And it's okay to make changes.
Yep.
There's nothing wrong with that at all, particularly from an activation and KPI perspective, because you don't know what you don't know.
Yeah.
You might find that if we use Western United, for example, they don't know what reach they will have with their new teams. So they could have an agreement that's not loosely worded, it still has measurables, but that can be reviewed after, say, 6 or 12 months. I did have a new client in the market recently, and for their agreement, they're 3-year fixed terms, but we gave an option to renew to either side to terminate without cause after the first year on 4 weeks' notice.
Okay.
So you've got a year to see how it's going. The parties, it's annoying if you have to renegotiate with a new contractor, but giving them that ability, because they were new to the market, they have no idea how it's going to play out. But for my client, they might have undersold themselves, so it's also giving them the ability to repitch. Yeah,
so it's exactly the same, in Western United's case, being a new A-League team, it's like starting the same as I am in the esports space at Gravitas. Like, here I am selling the fan zero story. A sponsor like, well, I don't want to sponsor a team that has 0 fans. I said, but we've got 0 fans now. What's it going to be? And then 4 months later, we've got this many fans here, and we're talking to this gaming group, and so that's evolving. And so, the price potentially moves from year to year as you're growing that fan base.
That's it. Front of shirt sponsors this year for the 2 new A-League teams might be lower than the other ones, but you might find for years 2 and 3 could double or even triple.
Yeah,
we just don't know, but all the parties need to make sure they've got that flexibility to renegotiate.
And that's where it is. You can get in, get the price in, and lock it in for 3 years, and realising you're getting it at a good price, and you're really getting a lot of value in year 3. But from a year 1 point of view, the new team gets that assurity of having a sponsor in year 1.
That's it. And I think for my view is number 1 is relationships. And that's why we're seeing it's almost the creation of a new role, the client relationship manager, as opposed to the straight commercial manager. That way they can keep up, I guess, the relationship between the parties. We even have it in law firms. We've got the client relationship partners. And my clients, a lot of them who have come to me, quite often they say, sure, we work with other firms, top tier, the most brilliant legal minds, but we only ever hear from them when they want free tickets to an event, or they're about to pitch for a tender and want to say we act for X organisation. For me, yes, it's extra work, checking in. I'll go in my own time. I'll fly around Australia to meet with them quarterly, see how they're going, learn what their business strategies are for the next 5 to 10 years. So when they come to me for a problem or they want to sign a big deal, I can go, well, hang on, remember you wanted to be in X country by this time?
Yeah.
It's all relationship-based, and I think
we are seeing definitely the commercial teams evolve in that space on that account service piece.
Yes.
And then also have that skill set of growing of how digital fits. Like having commercial people that can talk to sponsor and brands, digital people to be able to talk to the digital teams to go, oh, this is how we activate it, because their product has evolved over the last 10 years. They're not just selling the jersey and the hospitality and the signs in the stadium. They're selling, branded content and activations on social and activations on, at the stadium and how it gets activated on digital. So their scope of what they need to know is getting much wider.
That's it. And the human element has to stay. And I think the betting companies actually do that quite well, because if you look at the product they're selling, which is gambling, it can be quite controversial. Many governing bodies are limiting funding that can be given to sports or teams based on gambling revenue. But if you look at the Twitter feeds, they are absolutely amazing. They're engaging on a whole nother level. I aspire to have that level of wit to be able to commercialise a product like that. Some of them are a bit far-fetched tweets at times, but it engages everyone. And I now know which betting companies associated with, the funniest lines or the memes that come out.
Yeah, it's a really good strategy from a customer acquisition point of view. And if any industry knows its numbers around customer acquisition, it's definitely the gambling companies.
Yes,
they know what they're doing. And back to that point before, when they're going to do a partnership with their club, they are completely focused on how many new customers are you going to get us, and because they know the lifetime value of that customer. And so that's where I think, especially talking to my North American friends who are just growing into this gambling space, I think there's a real threat that they are actually potentially underselling what those gambling partnerships might be, because the gambling companies know how much Bob in Boston is going to bet and how much revenue they're going to make on him. It's going to be interesting to see if they price those correctly. Like we've seen some leagues go in early with their partnerships. Are they effectively getting enough money from those partnerships? It will be something we'll look back in a couple of years' time and see if they have.
That's it.
We're in Australia, we've seen those markets move for many years. So, Cass, I want to finish off with the Sports Geek closing 5. Do you remember the first sports event you ever attended?
Yes, I did. It was first year university when Lang Park was being refurbished.
Okay, up in Brisbane.
Yes, all games were being played at ANZ Stadium.
Okay.
Which was conveniently located beside my university.
Yep.
My very first game was Broncos v Eels, $9 entry fee for a student.
Yep.
Which was absolutely fantastic. I went to the game. Unbeknownst to me, I was actually wearing a baseball-style jersey, which was blue and yellow, being the Parramatta Eel colours. So I was wrongly branded an Eels fan.
Are you a
Broncos
through and through?
Yes,
yeah.
Brisbane girl through and through. And then afterwards, everyone jumped on board this bus to Caxton Street. I just toddled on with my friends and had my first experience out in Brisbane.
Yep.
Underage,
Yep.
unintentionally. It's a while ago now. Absolutely amazing game. I'll never forget it.
Terrific. And as you said, you've been to a few sports events, probably all in the corporate hospitality from your admission earlier. Do you have a favourite food memory or a go-to food at a sports event?
I should say 4 and 20 pies, but I guess I could say it, but I have an unusual way of eating them. Because,
You're not one of these people that pulls the top off.
Well, I am, but...
You don't eat it with a fork because we just have to stop this.
I know, caveat. I don't eat meat. So what I do is I'm usually going with some of my guy friends. Yes, I'll pull the lid off, but then
Yep.
I'm emptying the meat onto their pie.
Okay.
And I just eat the pastry.
Okay.
And I might whack a bit of tomato sauce on it. So I'm definitely...
So you're waiting for the 4 and 20 to come out with the pastry-only pie?
Yes, and they should. They've just signed those massive deals for the 2020 Olympics in
Yep.
Tokyo, the Rugby World Cup, and last week announced their first, Philadelphia 76ers.
Yeah, they're doing this stuff with the 76ers. You can get 4 and 20 pies.
That's it. It's the 76ers' first international deal,
Yep.
and it's with an Aussie company. So answer is 4 and 20 pies, but without the meat.
Okay, that is very strange. I'm hopefully when you're eating those, no one's taking an Instagram video because that kind of stuff goes viral.
It does. That poor lady recently.
The poor lady that was eating a pie with a fork. I mean, it's pretty much the same. Darren Ravel, he pulled out a knife and fork and ate a 4 and 20 pie when the 76ers announced, and he copped all hell from all of Australia.
Look, we're Aussies. We've got unique ways of doing things, but
Yeah,
please,
definitely.
Yeah, no one Instagram that.
So what's the first app you open in the morning?
LinkedIn.
LinkedIn?
Yes.
Okay. And is there someone that the Sports Geek podcast listeners should follow, whether it's someone on Twitter or maybe someone you read, and why?
Instagram, I would definitely say Hannah Gordon.
Okay.
She is the general counsel of the San Francisco 49ers.
Yep.
I want her job. Not yet.
Okay.
But I do want
You're
her job.
coming after her?
A couple of years' time.
Okay.
I'll come in as a deputy.
Okay.
Her life is amazing, but she just shows how the American sports world works.
Yep.
And what Australia can learn from it. On Twitter, I'd have to say Tony Pignata.
Okay.
Yes, he's a good friend, but...
CEO of Perth Glory.
Yes. The Ask TP sessions.
Yes.
I keep egging him on to do it more and more.
Yeah.
But he knows I'm going to ask him some ridiculous questions. But I just love the sass that comes with it. But that aside, the engagement with the fans of the club.
It is a really good case of how a
Love
CEO
it.
can engage, have a conversation, have the thrust and parry of, talking to people, dealing with the peanuts in the gallery that are always there when you have to go into that space. Tony does a really good job of that.
He does, and he answers any issue.
And so you've mentioned a couple of social media platforms. I'll ask you, so normally when I ask this, I ask it of, what's the social media platform is your MVP personally and from a team point of view. So I'm going to ask you from what's your social media platform, your MVP, and then when you've got your sports law hat on, what's your favourite one?
My personal one would be Twitter.
Yep. What's your handle for people who can send you a tweet?
Lawyer Cass with one S.
Yes.
Definitely Twitter. I love the reach. I love that it's raw and you don't have to rely on, I guess, scripted news articles.
And there is a really good, strong community of sports law. You can connect with different people talking, around the world, around the issues.
That's it. I went to Law and Sport Conference in London in September and I was on a panel. We had drinks afterwards talking with these people. We realised we'd never actually met in person, but we've been talking for 4 or 5 years.
Yeah.
It's just incredible.
Yeah, the familiarity that Twitter provides is terrific. And then from a is there a sports law platform?
LinkedIn.
LinkedIn?
You would have LinkedIn and probably to a lesser extent Twitter as well.
I think a few people have nominated LinkedIn. I've been a massive fan for LinkedIn for ages, and I think that the changes that Microsoft has made, whether it's a little bit more content and a little bit, has really improved the content that's flowing through. Some things they're trying a bit too hard, trying to push hashtags a bit too hard. They're pushing video a lot. But I do like the content and connections that's on this platform.
Yesterday they introduced, instead of a like, you can now clap as well. I haven't looked at all of the options.
There's different reactions of, pray hands and a clap and a good on you, which again, they're all tweaks. They're all signals to the algorithm. But yeah, I think if they, one of the ones that they brought in 6 months, it was, stickers on photos. And I'm like, no, come on, guys, let's leave them in. And so there's, you can see that they're the Facebookification or the Instagramification of LinkedIn. But I think mostly it's relatively good.
That's it.
And so most people, is that the best place for listeners to connect with you, to hit you up on LinkedIn and say, hey, Cass, heard you on the podcast, really enjoyed it?
That's it. LinkedIn and Twitter, always there.
All right, lawyer Cass and Cassandra Heilbronn, thank you very much for coming on the podcast.
Thank you for having me.
New workshops on audience, content, distribution, valuation, and pitch following Sports Geek's Digital to Dollars process. Go to digitaltodollars.com.
Thanks again to Cassandra Heilbronn. You can send her a tweet. She's very active on the Twitter, Lawyer Cass, Lawyer CAS. You'll be able to catch her. And as she said, very active on LinkedIn. We will have links to Cass's LinkedIn and Twitter on the website, sportsgeekhq.com/235. That's all you need to do, /235. You can just put the episode number to get the show notes and links to what we discussed. Before I wrap up, just a reminder, digital to dollars, how it can work for you or your team. If you're not familiar with it, if this is the first time you listen to the podcast, thank you. But the digital to dollars process is what we've developed over the last 10 years. It's developed over multiple different types of workshops where we're working with different departments in sports teams and leagues to help them better understand their digital assets and how they can best monetize those digital assets across departments, from commercial, data and digital. So the five pillars of digital to dollars are: know your audience, who are you talking to? And as I spoke about before, I'll be speaking at Youth Marketing Australia. What does your Gen Z audience look like? How are they engaged? What are they consuming? Know your content. What is the content you're developing? Who is that content being developed for? What are the types of actions you want out of your audience for that content? Know your distribution. So that starts looking at the different platforms, how they're engaging different audiences, how you're getting different outcomes. Is it engagement? Is it traffic? Is it views? What outcomes could you get your partners potentially out of those platforms? And not neglecting some of the old school platforms like email in that equation. Then the fourth pillar is know your value. So how do you start putting a monetary value on these assets that you're building? And what they're worth to your sponsors, because they provide the building blocks for the last piece, which is know your pitch. So how do you bring in the branded content, the data acquisition pieces, the campaigns that you might do, the stadium activations, those kind of things? How do you put it together in a fully cohesive pitch where all the parts of the puzzle that you can offer are available, and digital is appropriately priced and represented in those proposals? So if you're interested, it is very customizable. The first three work effectively as a digital strategy for a sports org or any organisation for that matter. And then the value and pitch components are really useful for the commercial teams to better understand and how to sell digital. So if you're interested in understanding more, go to digitaltodollars.com, or simply send me an email, Sean@sportsgeekhq.com. And the other thing is, if you do want to work, if you do find that you need some assistance, a second set of eyes or a second opinion or a sounding board, perhaps a Pick My Brain session will suffice. You can simply go to sportsgeekhq.com/pickmybrain and book in for a 2-hour session, a deep dive on the topic that you want to tackle. It might be a campaign you've got coming up, or a platform that you want to tackle, or a platform you want to revive, or an advertising campaign you want a specific objective to. So it can be as specific as you want, or it can be as general, looking at larger and broader trends. You can book me in for a 2-hour go-to meeting, discuss it either one-on-one with your key people, or do it in a team environment and get everyone involved. Happy to do that. It's a really good, I guess, starting point. Potentially, if you're thinking about if you would need my assistance, you can just go to sportsgeekhq.com/pickmybrain. Until next episode, thank you very much for listening. If you have listened on the Apple Podcast Network, I really appreciate leaving a review. You can simply go to sportsgeekhq.com/iTunes and we'll take you to the Apple iTunes store to leave a review. For those who've left them before, over 150 reviews so far. I really do appreciate it. My name is Sean Callanan, and you've been listening to Sports Geek.
Follow our League of Legends esports team at gravitas.gg. For more resources, go to sportsgeekhq.com. Looking for new campaign ideas to drive new and fresh data and leads? Contact Sean to find out how SportsGeek can help you drive fans into your stadium. It's all about the cheeks in the seats.